Thanks everyone for joining us. This Financial Boys webinar, Negotiating an M&A Deal, is part of the Private Company M&A Bootcamp for 2025 series and is sponsored by Max Asset. You can check out Max Asset on slide 38 of the deck. Actually, this is episode 5 of a 5-part series, so hallelujah, we got you all the way there if you've been listening to all of us on all of the various episodes. Slide 6 of the PowerPoint summarizes this episode, and slides 7 and 8 summarize the 2025 Bootcamp series. Speaking of the slides, we're not going to step through the slides in any particular order. You're not going to have to listen to us regurgitate any of the slides. Actually, I'm thinking for 2026, I might redo the deck. I've taken some notes to make it a little fresher for all of you. This webinar, like all Financial Poise webinars, is an informal conversation about the topic. You can keep the PowerPoint handy, however, because we may indicate what slides our conversation is touching upon as we proceed. Or if you're old school, like some of us, or like me, you could print out a copy and take notes if you're so inclined. We got a great panel today. We're joined by Bob Decker. Bob is Managing Director of the Peakstone Group located in Chicago, where he's responsible for transaction origination and execution with a primary focus on the food and beverage space. He's a career capital markets professional, an operating executive with extensive experience working with companies ranging from emerging growth to large publicly traded enterprises. He specializes in developing and implementing creative capital formation strategies and advising clients on alternate approaches for maximizing shareholder value in connection with M&A activities. We get Alan Graffin with us today. Alan serves as CEO of All Media Ventures, where he focuses on business development, capital sourcing, and board of directors services with and for private equity, venture capital, and media companies. Alan is an investment banker with Oberon Securities as well, and has over 30 years of experience raising capital and leading M&A transactions for media, licensing, and content technology companies. And he's closed numerous transactions in all sectors of businesses driven by ownership and monetization of intellectual property. Michael Weiss is with us today. He's the principal of Weiss Bernie LLC, which is a boutique corporate and real estate transactional law firm in the Chicago metropolitan area. As a transactional legal veteran, Michael represents privately and publicly held entities in business and commercial transactions, and he handles the negotiation and closing of complex corporate and commercial real estate transactions, both domestically and internationally. He's also a certified public accountant, and his experience includes all aspects of M&A, securities, and corporate governance. Lastly, but certainly not leastly, we're joined by Phil Buffington. Phil is a partner in Block & Bingham LLP, a full-service law firm located in the southeastern United States and Washington, D.C., where it represents financial institutions in a wide array of transactional and regulatory matters. I am your moderator. I'm Robert London. I'm an equity partner at Jasper Schlesinger & Rendren, LLP, which is a full-service law firm just outside of the New York City, Manhattan area. So I refer to us as being the New York City metropolitan area. We're in Long Island, just a stone's throw away from Manhattan. I do M&A, venture capital, startups, executive comp matters. Basically anything that's tough to negotiate and fun to draft and vice versa is what I do. I know you're thrilled to learn more about us, and you could hear us talk about ourselves all day because we all have such enormous egos, but in fact we don't. If you want to learn more about us, you can check out our bios at the back of the PowerPoint. This webinar is a production of Financial Poise. More about Financial Poise can be found on slide 39. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching or listening to this on demand or have any questions after the webinar is over live, you can send an email to info@financialpoise.com. Remember, the PowerPoint and the conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, accountant, or other appropriate professional. In other words, if you are silly enough to take significant action based on something you hear today or learn today or see in print in the deck, don't come looking up the bios at the back to come pounding on our door if things don't work out the way that you hoped. Once again, thanks to our sponsor, Max Asset. All right, let's get this party started. Today, we're going to be doing some mock negotiations on M&A deal points. Before we get into those mock negotiations, I'm going to make sure that all 3 of the Nevada, Las Vegas licensed judges are here so they can vote on each of the mock negotiations. They'll be texting me shortly. But for now, Let's get started with some general short discussions to set the stage for the rest of our conversations and mock negotiations. Many mergers and acquisition transactions negotiating points are colored by the types of buyers involved. Let's start off with Bob. Can you set the stage in that regard? Just
Sure.
generally talk about some of the buyer types.
Thanks, Robert. Great to be here. Most people are aware that there are generally two types of buyers, strategic and financial buyers. Strategic buyers are companies that are already operating in the seller's immediate industry or perhaps an adjacent space to that. They're typically looking to expand their scale, product lines, geography, or for other synergistic reasons. Financial buyers, on the other hand, are most often private equity firms, sometimes family offices. But typically, if they're making an acquisition in a new industry for the first time, they consider that a platform acquisition. And around that, they hope to, over time, do additional acquisitions in the space in what's typically referred to as a roll-up strategy. If a PE firm already has a portfolio company, that's somewhat of a hybrid transaction between a financial buyer and a strategic buyer. But the big difference is PE firms, what they want to do is create an entity that they can exit in a 5 to 7 year time frame. After they make the initial acquisition, strategic buyers, on the other hand, are really looking to hold on to the property indefinitely, whether as a standalone business or rolled up into their existing operation. Now, for purposes of this discussion, from a deal negotiating standpoint, one of the biggest differences between strategic and financial buyers is the form of consideration that's paid to a seller. Strategics will generally pay all cash, or potentially they might pay stock, though there are some advantages to doing a stock exchange. But in the case of financial buyers, it's generally a combination of cash, seller notes, rollover equity, meaning the seller will take some of the consideration and buy some of the stock of the entity, and potentially earnouts. And the financial buyer is really looking for the management team to be incented to stick around, and they'll structure the compensation on that deal appropriately to make sure that they do.
Thanks a lot. I guess in addition to the type of buyer, structure can be a dictating topic in figuring out which way deal points can be whacked up and negotiated. Phil, can you briefly talk about some of the high-level macro differences when our subject M&A transactions, either a purchase or a merger involving equity interests versus an asset deal?
Thanks, Robert, and good afternoon to everybody. As you said, there's basically two types of structures there: an asset deal, which would be a purchase and assumption, or an equity deal, which would be a stock purchase. When you're looking at the two, on the asset side, the asset deal, what you've got is the buyer is selecting certain assets and assuming certain liabilities, so they're really dictating the structure of the transaction within that. On the equity side, as opposed to that, the buyer is acquiring stock, which really means they're buying all the assets and all liabilities of the corporation. From the standpoint, like we're talking about liabilities, on an asset deal, buyers can go in and pick and choose which liabilities to assume, and that could be related to assets or related to lawsuits or any other liability. And then generally on the equity deal, as I said earlier, all liabilities except those that could be excluded through contract would be assumed by the buyer. And those would be known or unknown if they didn't discover them in due diligence. From a tax standpoint, what you have is on an asset deal, you have the ability to increase the potential for a stepped up basis in an asset deal, which is to the buyer's benefit. That may increase some tax liabilities for the seller. Again, we won't get into a lot of that. But on an equity deal, again, you're buying all the stock. So quite frankly, you may be able to use operating losses that are there, and you got the ability to use some of the issues under 338 under the tax code. Again, we could get into that all day long. From a documentation standpoint, On an asset deal, you're going to have more documentation because you're transferring assets and you are assuming certain liabilities. So you'd have different documentation to transfer real estate, transfer personal property, transfer other issues, which could include IP contracts or IP in general. On an equity deal, again, all you're doing there is buying the stock. And once you buy that stock, you're stepping into the shoes of the shareholders. And generally speaking, you have everything automatically. And that's it at a very high level.
Thanks very much. Let's stick with some high level other topics. I'll pick on Alan for a little bit. Alan, does it matter to the buyer whether the seller is going to be continuing on in the business in some capacity or simply exiting the subject business industry?
So it does matter. So the short answer is yes. There are four things perhaps for the audience to keep in mind. The first is business continuity often will look for a continuation of the founding team, the selling team. That business continuity can be through different instruments. It could be through a contractual. It could be through different ways of incentivizing them. But there is a desire for continuity, which often means that there's a desire to keep the selling party involved. That's point one, number one. Point number two, often it's exactly the opposite. The buyer is already in that business, knows how to operate the business. Perhaps the seller has some baggage, but in every instance, they don't want the seller to be in the building. They don't want the seller to be speaking for the company. They want the seller to leave the building. So that's a second point. A third is the element of a non-compete. A non-compete is an important element for most elements around a seller and the selling team. There needs to be some protection. That's often a highly negotiated, and also it's entered into legal matters. Different states have different restrictions. I know someone who had a 7-year non-compete, which was overturned and limited to 1 year. So non-competes are often something that comes into this. Those three items can be used in conjunction, by the way. Number one, you're going to stay for a certain period of time. And then two, you're going to leave the building super clean. Three, we're going to tie you up with a non-compete. And the goal of all this is to make certain that the business can succeed without the selling team or without the founder or without the parties that have brought it to this point, unless the buyer wants them to participate going forward. So that's a 90-second answer.
Thanks very much. I heard a little bit about restrictive covenants and the like. Although we'll be getting to financial deal points shortly, I think before we get there, it might be worth our while to talk about some of the strictly non-financial commitments that need to be negotiated. Michael, why don't you sort of show us what the forest looks like there from the copter?
Good afternoon, everyone. Very often in the transactions we all work on, the non-purchase price, non-financial issues can take as much time or more time than just negotiating purchase price and how purchase price is going to get paid, depending on the industry, depending on the deal. There are what we would call ancillary agreements, ancillary documents to a simple you buy the company for cash or you buy the company for equity type of transaction. There are restrictive covenants, as Alan just mentioned. For how long, what geography, what industry. I've been involved in a lot of deals, as we all are, where a seller is not necessarily retiring. In a strategic deal, a seller is doing other things, and as in some companies that are still has equity ownership in some companies that are similar to what he or she is selling, so need to negotiate all sorts of parameters of a non-compete. And sometimes we spend a lot of time really getting very narrow as to what a seller can and can't do post-closing. There's employment agreements or service agreements. If a seller or part of a seller's team needs to be negotiated. The buyer wants to make sure that he's going to get the benefit of the bargain of the labor and or services he needs to be successful in the business going forward. So we'll often spend a lot of time negotiating employment, independent contractor service agreements. There is transition services agreements, and I'll just name one or two more because I can go on about a lot. How much help a seller and a seller's team that will not be employed by a buyer post closing will spend transitioning the company. Will it be just a quick handoff, or will there be some time? There's also various license and leases, and again, depending on the industry and the type of deal, there's a lot of documents that go. And I also want to mention financing documents. Everyone here spends a lot of time in the transactions, if they're on the buy side or even on a sell side, and there's sort of a carve out of this asset from a bank line of credit. So we'll often spend a lot of time negotiating and revising all sorts of lender financing and even preferred equity type of documents. So it's a lot of work.
Great. So now it's time to show everyone the money. Uh, let's talk about purchase price and its various components. Again, without taking too deep a dive, because we will have a negotiation of purchase price in a little bit. Um, Bob, can you generally fill us in on what the general components are of purchase price that sort of make up you're looking in the McDonald's menu and, try to make your own Happy Meal here for a deal?
Yep, sure. So generally for sellers, cash is king. That first and foremost, a seller is looking for cash. And in the absence of cash, they're looking for something that is going to be able to be turned into cash in relatively short order. And what are some of those things aside from cash that can make up the components of the purchase price? Well, they can include such things as seller notes. Seller notes are often used, and this is where the seller is taking back a portion of the purchase price in the form of a note. Oftentimes it's used to bridge the difference between the amount of equity a buyer is putting in and commercially available bank loans that are out there, or even subordinated debt. But in the capital stack, seller notes are typically right at the bottom, right above any of the equity components. So the other thing about seller notes is they are preferred frequently by buyers because it's a ready source to offset any indemnification claims that we'll get into, where the seller has made reps and warranties, and they can reduce the seller note very easily rather than trying to claw back cash or dip into an escrow agreement. Another form of consideration is stock. With publicly traded companies, a lot of times stock is the primary form of consideration. And it can often be, readily saleable with some appropriate lockup period. But that is, typically looked at as a pretty liquid instrument for a seller. So, that's sometimes a seller will be willing to take stock, knowing that they can turn that into cash pretty quickly. In other cases, the buyer may request or require the seller, particularly if it's a important management team, to take some of the proceeds and roll it back over into the new transaction, trying to put everybody on the same page, basically. But if stock is issued in connection with a private company, then you get into a whole other set of negotiations for put rights and call rights, and basically giving the buyer the ability to buy that stock back, or the seller to achieve liquidity from that stock. Other forms that are common in M&A deals, particularly with financial buyers, are earnouts. Typically, earnouts are included when you need to bridge a valuation gap between what the buyer is prepared to pay and what the seller is looking for from the business. These are often structured as 3 to 5 year earnouts. Sellers obviously prefer a much shorter period of time. but there are lots of elements that go into negotiating earnouts. For example, what metrics do you use? Is it based on increase in sales or increase in EBITDA? How do you measure those, particularly when it's private companies? Are those based on GAAP? Is the buyer allocating overhead to the business? All these things come into play, and it's a pretty exhaustive negotiation. And there are also governance issues. Is the buyer completely controlling the business, or does the management team have the right to, continue to run the business the way they want in order to earn that earnout? And there are some other considerations as part of the purchase price. They can include things like holdbacks and escrows. And even I know that Alan referenced non-compete. Sometimes there's a separate payment for non-compete. So those are all elements that go into consideration for M&A transactions.
Thanks a lot. Alan, can you briefly address some of the ways that buyers derive valuations for making their bids? Let's say you're the buyer financial advisor, and I am the one only time seller of a family business, and I got your number, and I've just have you on the phone. I'm like, how in the world did you derive this number? And can you just talk about some of the elements and how typically valuation is ascertained by let's keep it at
Sure.
financial buyers for now.
Sure, Bob. I have 5 ways to derive value, but the most important one, frankly, if as a banker, is what the market will pay. But in order to justify the boards, there are essentially 5 that get mixed together. The first is recent sales. If you're making widgets and your main competitor is making widgets, you will want to know what that sold for. You might like it, you might not, but that is one thing that is often used. So comparable sales. A second is, and this is perhaps the most common, if there's going to be one, is multiples of EBITDA, multiples of earnings, because that is a very firm, recognized valuation metric that is used widely. A third would be discounted cash flow, where you go out a certain period of time, 10 years usually, and then you discount back. You have terminal value. That's an involved financial exercise, a bit more involved perhaps than the first 2. A fourth is what the value is to the buyer, and that comes close to what the market will bear. So, for instance, in this Warner Brothers, Netflix, Paramount deal, the Wall Street Journal, and actually there was a great analysis that it's 22 times forward earnings, which is very high. But when you take all the synergistic earnings, it's only 14 times. So you can be sure that the board found that all very interesting, and the seller found that extremely interesting because they're getting 22 times earnings. So that's the strategic value. And then a final value, which I don't bump into very often because I'm not in hard assets as much as others, is what would it cost to build that factory? We're buying a factory, we're buying a business, they make widgets, they've got land, they've got a building, they've got equipment. What's all that cost if we were to build it right next door? So those are the 5 ways that are often used. Sometimes all 5 are used, sometimes one comes to the fore. But generally speaking, those 5 cover the gamut of ways to value an enterprise when you're putting in an offer.
All right, I'm going to play my moderator card for a short digression.
Let's go.
What's everyone's thought on whether or not that merger is going to be approved? What are your thoughts?
I want to hear everybody else's thought.
Well, no wrong answer.
Knowing Larry Ellison's connection to the Trump family is certainly a wild card in all of this.
Mhm.
And Trump has already weighed in on that, trying to sort of tilt this thing towards Paramount. But of course, Paramount has come back with with an aggressive bid and an unfriendly bid. So they're really throwing a monkey wrench into this. I don't know where it's going to all shake out.
Yeah, I to weigh in, I think we would all agree that this is becoming more political than legal, and the whole issues. I don't know that any of us are antitrust lawyers, but there's definitely some competitive legal issues. But the politics seem to be injecting themselves somehow. So it'll be interesting.
I'm going to go
Uh,
after Phil. Michael, I'm going to riff on what you had to say. Phil?
I was just going to reiterate what Bob and Michael said. I mean, I think the problem is it's become politicized and not legalized. And what you're looking for in transactions are consistency. And from the
All right.
political side, it's going to swing back and forth all throughout the transaction. So where it ends up, I think, is anybody's guess at this
So I
time.
have 2 points. One is everyone on this call should find it shameful that a business transaction is being unduly influenced. Second, I think Netflix is going to drop out because the analysis, they are taking a 14,000 person business and buying a 30,000 person business, Warner Brothers. They are going from being high tech, worldwide, fast and nimble to a legacy business. I don't think Netflix is going to match. I think they're going to say thanks. They're going to take their 3 billion breakup fee, and I don't see them matching it. And full stop. Thank you for asking an interesting question, Bob.
Okay.
I
I'll
don't
put
see
the cherry. I'll put the cherry on the sundae, which is I also look at this as no risk to Netflix because the worst case scenario for them is they've tied up a big competitor from its growth for probably a year if it doesn't get approved, right? How long is that, that approval process going to play out? You've basically hamstrung one of your largest content competitors and technology platforms in your space for a year because they can't really grow, they can't really do anything during that time.
Yeah,
So
but both of them. And Bob, not only are you spot on, and forgive me, this is what happened to CNN when version number 45 interceded shamefully and tied up CNN for 2 years. So I think that's a valid observation.
all right, let's go back on track now. We're going to do some mock negotiations. I'm going to start with Phil and Michael. I'd like to engage in a mock negotiation of typical deal points that arise in the early stages of a deal when the buyer or seller are considering entering into a letter of intent. Phil, you take the buy side. Michael, you take the sell side. Viewers, bear in mind there isn't meant to be a winner here. The judges from Las Vegas got held up at TSA pre-check. So the mock negotiations of these episodes are just to give color to the subject deal points. For this purpose, let's assume the purchase price payment methods have already been agreed to. So, Phil, why don't you start off by taking the buy side by saying the things in the letter of intent that you really need to address and include as buyer favorable?
Well, on the buy side, a couple of things that I'm going to want to do is we talked about the price you got there. I want to know what the structure of the transaction is. I want to know if there are any contingencies there. One of the things that I want to know too is what are the breakup fees going to be, or the reverse breakup fees going to be? And keep in mind that a lot of my transactions are with financial institutions where we've got those breakup fees in there. And most of the time, the agreement comes to you with only a breakup fee. So that's what I'm interested in on that part is the breakup fee. The transaction timing is important to me. Tying up senior management's important to me. I'm trying to think what else. Confidentiality, the due diligence time. I want to streamline due diligence, but I want it to be complete due diligence. So those would be my high points that I'd want to have included in the LOI. I'd take the position that most of them are pretty standard and wouldn't have to be negotiated very, very far. And I could give that to Michael and he would just agree to it.
on the flip side, on the seller side, and I'm going to put the issue of a breakup fee to the side. Um, with a lot of industries, and there are exceptions, but under normal circumstances, in most of the deals I work on, there generally are no breakup fees. Each side is um, taking the risk, spending their own money on accountants, lawyers, and studies, and they're just going to. But there are exceptions, and I have had some negotiations over breakup fees. So let me put that out there. On the sell side, What I really want is to I'm willing to give an exclusive because I understand if a buyer is going to spend money and really look into a business and be serious, they need to do it knowing, we're planning on going to the altar. So I'll give you exclusivity, but I want to keep it as short as possible. Because if we progress through due diligence requests and so forth, and I get the feeling I don't know how serious you are as a buyer. You have 10 other deals going on. I'm a low priority. I want to figure out if we're going to do something together or I want to move on. So I want to keep that period short. I want to put I'll cooperate, but I want to put most of the expense on you, buyer. I'm willing to put in some time and money to get this deal done. Of course, I want exclusivity. I'm sorry, I want confidentiality as well as you do. I think we all agree on that. Um, but I understand if it's a really great purchase price, boy, I want that to be binding. But I understand that it usually isn't, and structure isn't necessarily binding. So the key things I'm really focusing on are the length of time. My client's business is off the market on exclusivity. I want you to be streamlined. Um, and I'll give you the due diligence, but I want the clock moving as quickly as possible. And, I understand from your standpoint, you want real due diligence and you want to make sure I'm responding to what you ask. So I think everybody on the panel can sort of argue both sides. We've all been doing this long enough in the same conversation.
So I'll ask you both, how do we solve, you said, how long did you want the exclusivity period to be? What do you think is, from the seller's point of view, market? And then, Bill, um, what would be the rebuttal if you feel it's too short about under circumstances under which you could extend? And that would, sort of be, what would be the norm? Where do we end up there? So, Michael, give us a time period, and
I'm just
then
going to
Bill.
pick 90 days because 90 days is a time period I've used a lot. 30 days is too fast. 6 months is too long. Depends on the industry, depends on the players, but in a private world of privately held companies, I see 90 days a lot. I do see shorter, but I'm going to say 90 days.
And Michael, is that for closing or to get a purchase and sale agreement?
To get a
Finally.
purchase and sale agreement. Brings up, it's actually a great question, Bob, because then there's a question of are we going to have a sign and close, or are we going to have something else? And I would say probably 75% of the deals I work on are sign and close, whether it's a stock deal or an asset deal, but that plays into it also. But if before the end of the 90 days, you're not going to close. Maybe you can get the purchase agreement done pretty quickly and provide in the purchase agreement, which will supersede the letter of intent, your map forward.
Yeah, and Robert, really, I wouldn't have a hard time agreeing with anything Michael said. I mean, I'm fine with the 60 to 90 days. This is where I would come in and say, if we're going to take a shorter time frame, I'd want to do this. I'd want to be preparing. I'd want to start the due diligence, and let's just take 90 days. I'd want to be 60 days into the due diligence to make sure it's something I'm going to want to do. I'd want to start working on the agreement and let the due diligence continue up until 90 days, but be working on that agreement in the last 30 days, because depending on the level of sophistication of the buyer and the seller, it's inevitable that something may come up as you start negotiating that agreement that one or the other party hasn't thought about in due diligence, that triggers something that we've got to go back in and investigate. But from start to finish, 60 to 75 days on due diligence, 90 days to have a signed agreement and just a standard transaction without any regulatory oversight. I think that would be something that I could agree with in most instances. Again, getting back to what Michael said, depending on the parties, depending on the size of the transaction, and depending on the industry.
And I go with 30 to 45 days. When I'm representing a seller, I have them work on the due diligence like the day I step into the market, which then takes X number of weeks or months. The due diligence should be all ideally done when the first person hits it. 30 days with an extension of 45, and can always be extended if things are looking really great. But I try to limit it if I'm representing the seller, which I usually am. Thank you.
I think from the buy side, I would be pushing back very hard on that time frame. I don't think entering the fray here and taking off my moderator hat, I would say there's no way my client's going to invest money in due diligence on a 30 to 45 day period unless there's some sort of automatic right of renewal if, on optionality, even without some sort of, sometimes see a standard that, good faith dealings are ongoing or progress is being made. To me, 30, 45 days would be.
So I want to unpack the due diligence from the exclusive.
Mhm,
They can do due diligence. I can have people doing due diligence for weeks
mhm.
and more. But if someone shows up and it's a letter of intent and the client wants it, then the buyer has already done most of the due diligence by time I let them get to an exclusive. But that's just me. So
And Alan, I follow that, but again, a lot of that's in the seller's hands and providing the information. And if the seller's slow to provide that information, I go back to Robert's comment. I might agree to 45 days to close, but what I'd want built in is 2 30-day extensions that gets me to my 90.
Right.
And I'd want it based on conduct of the seller or information that's being provided, because I don't want to get 45 days or 40 days in and another offer's there, and on the 50th day or the 46th day, you're telling me that we're taking another offer.
like I said, I usually represent the seller.
Yeah,
Right.
I know, and I get that. Look, I agree with you on that side, but on the
Well-
buyer side, I'm like Robert. I'd push back on that. But Robert, I interrupted you. You go
No,
ahead.
as the buyer in that situation, I want to have the only key to the data room
Right.
for a goodly portion of time. I don't want to be
Right.
competing against anyone else. If you like my price and I'm in the ballpark, I'm the only one with the key to the data room.
And let's back up, because if we already have a data room, and Alan, you've run through a series of potential purchasers and you've settled on my client, then I want everybody else excluded until I have a time to do all my due diligence. And you've had other people get in there and been able to vet them to determine who you wanted to focus on. So
And
that could be a mitigating factor too.
And it's important for the buyer to put in a no shop provision in there as well.
At that
Yeah.
point.
Yeah.
Okay.
All right, let's move on to some of the money. Let's say we have a general idea of what the gross purchase price is going to be. I'm now going to invite tough seller guy Alan and Bob to have a short mock negotiation on how purchase price is going to be divvied up at closing. Let's take the situation of a private stock deal with a strategic buyer. Alan, time to get rid of your sell side hat and put on a buy side hat. This should be fun. And Bob will take the sell side. So, Alan, you're protecting a buyer here.
A buyer.
What's your
Okay.
ask on how you're going to try to protect the buyer purchase price wise?
Okay. So a price has already been agreed upon, and now it comes down to how that money is going to be divvied up. So as representing the buyer, we're going to make meaningful cash at close that will be life-changing, will be legacy money that you will be able to share with your children. You want to close. The buyer, in addition to putting all that money up, has a second and third wall of protection, because in order to get this deal protected, there needs to be a significant escrow, an escrow that if something isn't quite has presented, if something isn't quite exactly has understood and presented, then there needs to be an escrow, and there needs to be a rapid way to get to that escrow. And then third, as part of that, we want to hold back a significant portion because we want to make certain that you're focused on implementing whatever we've agreed to. So those are the three components that in order for this deal to go forward at this very attractive price, we're going to make life-changing cash on the table you're going to walk away from. We're going to have an escrow of something less than 7 years. and we're going to have a holdback. That was a wink. And we're going to have a hold, we're going to have a holdback of some of the money. I saw an escrow of 7 years, guys. Just saying.
Well,
Wasn't my
Alan,
deal.
Not on any of my deals.
I
You
was on
didn't.
the selling. I was selling, and there was
Right.
they put an escrow on this poor company. Anyway, all right, Bob, try to beat that.
so thank you for all the platitudes about, me having the cash and, all the things it's going to do for my family. But, cash up front is king today. And one of the things I'm going to do, if you're going to push for a high escrow here, is I'm going to suggest we get reps and warranties insurance on this. That will reduce the amount of cash holdback on this. And the research today says that when you have reps and warranties insurance on a transaction, less than 10% of the purchase price is typically held back on that. And in fact, of that 80% of that is less than 5%. So I really want to get reps and warranties insurance in here. We have a very clean business where, hey, we're also prepared to put our money where our mouth is. And, we'd be prepared to take back a seller note. We'd want that repaid within, 12 to 18 months. So that's that cash is ours sooner rather than later. And to the extent that you wanted to put an earn out into this thing, then we're going to have very strict governance over this in terms of how we get to operate the business. Very objective measures for all of this because we don't want that to be a discussion point 2 or 3 years down the road when we're doing this. So I think it's really important. Again, stressing the importance of cash being closer to the closing rather than pushed off into future dates.
I'm going to get us a little into the weeds now, because it was mentioned before, I think it was by Alan, which is the seller note is almost always deeply subordinated, um, just a stone's throw above equity. I have seen, at least with talented seller counsel, have requested, and it's been hotly negotiated, uh, either intercreditor or not, anti-layering provisions in seller notes to make sure that a pile of debt doesn't come on top, or even, I'm not going to say bank credit agreement like cash flow covenants or debt covenants, but those types of covenants light just to make sure the seller note doesn't get underwater. What's everyone's experience there? And then as a follow on to that, I'd like to talk about, are there any ever certain situations other than default where the seller note gets triggered and gets paid sooner? Anyone can jump in and I'll tap the first one who chimes in.
Well, I think that, provided that the buyer is achieving certain debt service coverage ratios, post acquisition, the seller is going to want to look to provide, whether through an intercreditor agreement or an agreement, a carve out within the bank loan to allow for this seller note to be paid, or at least a portion of that seller note to be paid in as short a period of time as is practicable.
Do you often see the intercreditor agreement at closing as well? Because I've seen plenty of deals where it's not on the table until someone like me or anyone else here on the panel says, you know, what about an intercreditor agreement? I don't want to be blocked. I don't want to
Yeah.
be tortiously interfering with the bank. I don't want, like that's like, chief among the list of ancillary documents when you have a seller note. How often do has anyone ever seen deals close without it, and have any problems ever arisen?
No, I would agree, Robert, that there usually is some type of intercreditor agreement or verbiage in the senior loan documents that address the seller note. And it could get a little sticky. And if I'm representing, the sell side, as you mentioned, I absolutely want something there. I don't want to be, completely unsecured, high and dry. I want as many covenants as I can get, really for purposes of getting a seat at the table should something go wrong. I mean, there's a problem with the bank loan. I, then I, as a seller note, waiting for money. I want a seat at the table as to how we going to resolve this, how we going to fix it. I do want some type of provision in my note, of course, if there's a change of control or other liquidity event, I want to get paid. But I think the key thing is, as a seller, you really don't want to be standalone. If you have to be, you have to be, depending on the deal. But you want to integrate your obligation as much as you can with other type of financing or obligations. You don't want to be just a simple the level of a trade creditor, because then you've got nothing but a handshake.
Would it be can you rebut if the buyer just simply asks that you will agree in your seller note to sign the senior creditor's customary form of intercreditor subordination agreement, or are you going to need to see it?
I am curious. I need to see it
Okay.
because every standard form is not a standard form. I
All right.
noticed in dealing with different lenders, every form is different. So I need to see it.
Okay. All right.
Robert,
Let's move
Rob,
on. Unless,
Rob, before we leave that, can I just throw in one point?
of course.
We hit the two main parties in there, but there's really a third main party in that transaction. If Bob's buyer is borrowing money from my bank client and 80% or 90% of that purchase price is being paid to Alan's client, and Alan's client's taking a 10% note, my bank client's sitting there saying, if something goes wrong, I've got to have the ability to provide additional financing. And that's what everybody needs to know. The bank is the 600-pound gorilla in the room that's going to say, no, I need to be protected to make sure my lender-borrower relationship's protected, and I can protect my investment in this business, and that Alan's client's not going to be able to dictate, having gotten 90% of the purchase price, has got a 10% note. So I think that's something everybody needs to realize, that this isn't just buyer seller. This is going to be bank saying, this is what I got to have too, just like you're saying on the intercreditor agreement, because they've got the money in the game at that point in time.
Which gets you into the weeds of having to come up with a workable definition of what senior debt is in the document, and then intercreditor wise, how long the block is, is accelerate upon an event to default or just a default. We could actually have a whole seminar on banking. All right, let's go stick with purchase price. Let's get into earnouts. Bill, you take the buy side. Michael, you take the sell side. Let's negotiate a few deal points which might arise when the buyer requests an earnout. Bill, you can get us started.
Okay, Michael, what I'd do is I'd come in, I'd offer you a certain number of dollars a share. Let's just say $100 a share. And then I would agree to give you an additional payout of $20 a share or $25 a share. Let's say 25%, $25 a share. But it's based on us getting certain approvals of products that you have out there in the marketplace that have to get regulatory approval, and making sure that not only we get that regulatory approval, but that we're actually able to develop a market for it, and we're able to sell that market within, let's say, a 5-year period of time.
I am really happy in the real world that I don't have to come up against Phil, because he would no. I would say, Bob hit the nail on the head throughout the program when he said cash is king. And when I'm representing a seller, boy, I like cash, because I know anything else is going to have some ifs, ands, and buts, and so forth. But hey, we have Phil's client and my client have negotiated, or not. That's the deal. I wasn't involved in transactions. The cash in is king. Comment kind of went off to the side. Sorry about that. But when I'm a seller, a couple things with regard to an earnout that I've agreed to. I want it to be very well defined. Very because I have sold the company. I'm not in control anymore. If I have to go litigate this issue, I want it as clear as possible. I don't want any fuzziness. Also, I want information, and if possible, I want some approval right as to what buyer is going to do post closing. Remember, buyer will be in control of the company in order to achieve those goals, because I need those goals to get achieved, whether they're product approvals or revenue metrics or profit metrics, in order for me to get my money. Certainly, I want to put in language that buyer's going to use best efforts to achieve these goals and various metrics. But on the sell side, we're always nervous about earnouts. We want something drafted as tight as possible. We want to see the path forward, and really, know that there's the ability to get this money and earn this money. And if I sell side, need to be involved on a transition agreement post closing to help ensure that, well, that's great, because that's $20 I really want in my pocket. And now putting on the flip side for Phil's, there's always a little tension here, because Phil's client is now saying, "Hey, I'm going to be running this company. I'm there to do the best I can to get your urine out, because that means I'm making money." So there's up and back. I probably spend a disproportionate amount of time, I think, as a lawyer, on the buy side or the sell side, drafting earnouts. Not that the other agreement, Phil, and I'm curious about you too, not that the other provisions of the agreement don't take a long time, but the earnout is often not as standard as other terms, and people are really sort of fighting for every word on the earnout.
Well, and I would agree with that. I mean, I think that's an issue that really has to be. And let me back up and say this. I would agree with you that it needs to be well defined, because if I'm the buyer, what I don't want is, I don't want to buy into litigation with my seller. I want to have an agreement that we know we can move forward with. And I'm probably willing to give some. I'm not going to be willing to give control rights to you, but I'm going to be willing to give input rights to you. I'm going to be willing to give some opportunity to approve, to work with me to get a budget in place. But there's so many variables there that I need you to be exercising good faith on. If you're leaving as the seller and your senior sales team is in place, and then they start abandoning ship, then everything kind of goes away from me, unless I've got a succession plan there. So I really have got to have you bought into the plan, and that's why I'm trying to keep you there. But again, I go back to, at the end of the day, if you can find the sweet spot for the parties and they're exercising good faith, and you've got something well defined, then the chances of conflict are less, and the transaction is good for all.
I think Phil, just last comment, hit the nail on the head. It really is a sweet spot between the parties. And the funny thing about it, Phil, is sometimes that just takes hours and hours and hours, because one starts at the North Pole, one's at the South Pole, and to get to the equator takes a lot of machinations.
Well,
but I agree.
and Michael, I'd always turn around, and if you were telling me that everything was going to be great, and I was going to make all this money after my purchase, my first question has to come back with, why are you selling? Why don't you just find somebody to run it for you? If it's that sweet of a deal, then I don't need to be buying it. You need to be keeping it. And I do agree with you. You've just got to find the place where the parties can meet, have a meeting of the minds, and move forward, or go separate ways.
I want to go fishing.
I'm going to play my moderator card again, because I want to move us along and touch on indemnity. But before I do that, I want to surprise Alan with a question, which is, do you think the marketplace, the principal buyer and seller business people, have the appetite to watch lawyers negotiate and draw a proper earnout provision that adequately protects the seller? Because it can be quite, quite the legal spend. You're on mute, Alan. There you go.
I was mesmerized by the legal back and forth, so I'm glad you asked that question, Bob. No, I don't like earnouts like that because first you mentioned a primary reason. Second, the amount of time, energy, and potential for hard feelings is very high. And there is it's like if the seller is supposed to contribute to the success, then I don't like best efforts, even reasonable business terms is sometimes. So Bob, it's not something that I try to stay away from it. I try to encourage my sellers to stay away from it. There's other ways to address it, but it should be his passive and not involved of the seller, because otherwise everything that you just heard gets a lot of attention, money, and friction.
Okay, so let's end on friction. Let's talk about indemnification provisions. Bob, you're a buyer's advisor. What would be your most owner's ask indemnification wise? And then Phil, you can close us out with a counter.
So, who am I negotiating? Phil, we have some serious concerns about certain parts of your client's business, and we're asking for some very broad indemnification provisions to cover these potential liabilities. Since we can't determine the ultimate cost of these potential liabilities strictly through due diligence process, and we're not able to secure reps and warranties insurance from a third party, here's what we're going to propose. We're going to have uncapped liability on this, meaning there's liability over and above the purchase price for your business. Two, we're going to have a significant escrow. In this case, we're going to ask for 30%. And that's going to be held as security for us for a period of 3 years. And then we're not going to have any baskets or deductibles in that indemnification. That first dollar recovery for any liabilities that are discovered post-closing. And that's just for starters.
Go
Well,
get it,
Phil. I've got to go back, and I can't remember if this was Michael or Alan that said this. I don't want to negotiate with Bob.
I want to take you back out to market, Phil.
But I really, from the standpoint of if that's where we start, this kind of be my response. You've already worked all of that into the pricing, so you know what your risk is. Maybe you've got some unidentified risk, but certainly it's not 30%. So I would take exception to that. Whatever percentage I agreed to on an indemnification holdback or escrow, I will tell you, my thoughts on those are their statute of limitations. And so your exposure is going to be limited to 3 years, and it's going to decrease as each year passes. And so on any kind of escrow or indemnification fund, I'm going to want it released at least a third annually. And so it's going to be diminishing as we move forward to that 3-year period of time. And that's what we could at least start talking about. But this is the point to where I'd really have to find out whether or not you were really serious about buying the business and whether or not we could resolve some of the due diligence issues that you have, or whether or not we need to really just go separate ways and let me decide whether or not my client needs to keep the business or move on to another market. But I do want to go back and say one thing about that. I think it's really important, not just from a lawyer standpoint, but all advisors, to be really clear with what their clients want and what they're willing to accept, because lawyers sometimes get bogged down because we don't really understand what our clients want. And that's what, Robert, you ask about. Does the market want to listen to us go back and forth? The answer is no. It's up to us to find out as advisors what our clients want and we're willing to accept, and try to close the deal in those parameters as opposed to kill a deal.
Well,
All right.
Phil, we're just trying to protect ourselves from those exploding asbestos dolls that you made, for the product liability and environmental considerations. So, we need a lot of indemnification here.
They were in contained skirts.
All right, well, let's close this deal. Thanks again, everyone. This was a really fun one. No winners or losers in the negotiations. I hope that we helped the attendees and viewers focus in on a few deal points. Happy holidays to everyone. You can look for me and these wonderful panelists again in 2026. I'll be doing the four-part series on startups. And James Bond, I will return to host the 2026 five-part series on private M&A. So until then, happy holidays, stay well, and we'll see you again. Thanks, everyone. Really good one.
Thanks, everyone.
Happy holidays, my friends.